my client, who was the mother, was employed as an exotic dancer.
If the child's a witness, they have to testify in court.
On what their risks are and what it's going to cost them to get what they want and whether that is worth it.
Besides, you're dealing with a situation that is highly personal.
Best interest of the kids, that's what you're focused on.
So Matt, when I did practice family law a number of years ago, I was retained on a file which was particularly contentious involving a child. And the fact pattern of it will help you understand why it was contentious. So my client, who was the mother, was employed as an exotic dancer, and she had a child with an MMA fighter. And they weren't involved in any sort of a long-term relationship. It was kind of a one-off, and they had a son as a result. And so my client was unfortunately bipolar. And so all of these little variables made it into a very difficult situation to deal with, not just for the courts, but amongst themselves, the two of them, the mother and father. And so as soon as the child was born, immediately they were in front of the courts getting a variety of different kind of orders.
Yeah.
And so I became involved when the child turned 5, and the mother relocated with the child to a different province. And the reason was because, what she was doing for work isn't really sustainable, and she ran out of options. Her mother is a successful realtor, and so she felt that moving out of the province and living with family would be better for both her and the child. She did this without getting a court order, and so immediately after she moved, the father, within about 15 days, was able to obtain a court order compelling her to come back to Alberta. Mm-hmm. We were able to get what's called an interim mobility order, which allowed the mother to reside outside of the province until the matter was put to a hearing. And so, during the sort of what we call the interlocutory period, the period between the order was issued and then the hearing took place, it took about a year, unfortunately. You've made reference to how under-resourced the legal system is, but it took us over 12 months to finally have a 1-week hearing to have the matter determined. And during that time, there were a number of troubling allegations that were made of things like, drug abuse, and also allegations of abuse of the child. And finally we had that 1-week hearing. We were successful. The mother ended up being able to reside outside the province, but at a great cost. What I found interesting throughout the process was that despite the circumstances, the court didn't call on the child to testify as to any of what was happening.
No.
So why is that? Why don't, even in troubling cases like that, is it uncommon for children to come and testify in family law cases?
No, it's not uncommon. The courts don't want the children involved in these legal battles at all. It's too much toxic stress in that they want them to be left out of the discussions between the parties. They don't want to be asked questions. They don't want the children involved in any capacity if possible. That's not always the case, as there is a lot of stuff where the kids do get more involved. There's allegations that from abuse from the kids, or there's kids get a little bit older and they want to have a say in certain things, or start having resistance dynamics where they're resisting to go to see one of the parents. But the courts have a number of different avenues to determine what the kid is saying and getting that evidence from the child without putting them on the stand, because they don't want minors to be on the stand and being questioned or anything like that. And
can I clarify, when you say on the stand, you mean one lawyer's going to do a direct examination and then presumably subject to cross-examination?
That's right.
So neither of that. It's not even a situation where they could get up there and the judge can ask questions.
So in some cases, the judge will have a conversation with the child privately outside of the courtroom, because they don't want them in that open court for the most part. What they typically will do is, in the court system, there's a couple of avenues. There's a practice note 7 voice of the child report. So you have a parenting expert meet with the child, determine what the child is saying for their views, whether they have the capacity to give those views, and if there's any outside influence or coaching or anything that would affect their ability to give those views. And then the courts can look at that and what they're saying, because what the child's views are in some of those is still only one factor under what's in the best interest of the kids under Section 18 of the Family Law Act and 17 of the Divorce Act, or 16, sorry, one of the two. I think they both go into that. But it's still just one factor. And so you still have to balance what that child is saying against the other factors. So, with a 5-year-old, 5-6-year-old, they don't know what's best for them. So they're not given a lot of weight to their voices. When they're into their 10, 11, 12, they might be given more of a voice, but it's a voice, not a choice. When they get more into 14, 15, they get more of their views heard. When they're like 15, 16, 17, well, at some point the kids are going to speak with their feet at that point, and a court order is not going to stop them from going to the other parent's home.
Yeah.
So the big question I think what you're asking about is how do they get that evidence from the child? And so there's, like I said, the practice note 7, voice of the child report. You could do another type of practice note 7 where there's actually like an assessment of the child and like a risk assessment or a parenting assessment. There's also a full-on what's called like a bilateral assessment, practice note 8, where they'll investigate the whole family and everything and try to actually figure out what's the best schedule for the kids and make recommendations on that schedule. Those cost a lot of money, so not everybody can do those. So there is other options like having counsel for the children appointed. So there's actually a lawyer who's specifically trained to deal with children and represent children, and they get appointed by the courts, usually through legal aid, to act on the child's behalf. Parties can retain people privately if they agree, or you go to court, get the court order saying that one's going to be appointed, and then usually legal aid jumps in and points from there.
And that's funded by the court, so it's not a situation where parents who don't have access to funds would just not be able to do that.
Yeah, if you don't fit the legal aid requirements, then there might be some that the parties have to pay for that. But for the most part, it's funded and covered. That's my understanding. Then under that too, you should be aware that there's about 3 different roles that child's counsel can play. They can take the advocacy role, where if the child's old enough and has the capacity to give their instructions, they will act as that child's lawyer and fight and represent them as counsel and giving the court their views and what they want to do. There's a friend of the court type role where the child's counsel will just meet with the child and kind of advise the court of what they're saying and why if they have any concerns about why they'd be saying it and that kind of stuff. Or there's even another one where they kind of do more of an assessment close to that voice of the child report, but they'll look at everything and give some advice and direction to the court on what they feel was in the best interest of the child.
So you always have the involvement of some third party when the case involves a minor, let's say a 5 or 6-year-old. The court's going to rely on information from a third party to provide them with if they want to make a decision about something. Is that sort of the case?
Yeah, usually the courts, again, you have to have a really good reason on why the kids' views and voice is being brought in.
Right.
And usually it'll be that resistance dynamics. One of them doesn't want to see the other parent or something, and they'll try and get to the bottom of that. You're honestly better off getting into the therapeutic intervention of the practice note 7, like a reunification therapy, rather than fighting about what they're saying and whether they should be saying it or not. Because again, with the time you'll get to determine that, you're going to end up in that therapy anyway. So just start there and start working on that relationship if there is resistance dynamics. If you're getting into like abuse allegations, then some other stuff also gets brought in. Like if a party is saying that the child has reported sexual abuse, there's a whole other avenue that they will take from that. It's a practice note 5. And if you make those allegations, you've got to submit a PN5 form, which will then go to Child and Family Services, who will then start investigating using like the Luna Center or some other body to see if those allegations are somewhat substantiated. If there's no concerns, then it's done. Then you can't really even rely on those allegations anymore. But if there is concerns, even slight concerns, then they'll further that investigation to get to the bottom of what those are.
So just something that you said there, if the allegations are unsubstantiated and there's no concerns, you're not allowed to rely on them anymore. But if there's even a little bit of concern, there's still an avenue to go through. So, if those allegations turn to criminal charges and the criminal charges are dismissed, obviously there's a very different burden of proof between family law, which I believe is still balance of probabilities essentially, and criminal law, which is beyond a reasonable doubt.
Right.
And so in situations where those allegations are not substantiated in criminal court, does that have any weight or bearing on whether they are no longer a concern in family court? Like, does an acquittal mean it can't be used anymore?
Most likely, I would say, yeah, because if you go all the way through the criminal process and you are found to be innocent there, those allegations didn't happen.
It's as rigorous as you can get under the criminal system, right?
Yeah.
Well, I guess that's why I'm asking, though, Tahir, because beyond a reasonable doubt means you have to be able to convince somebody almost certainly that it happened. 99.5% if you're looking at numbers. And if the test is, there's no concerns, is there any sort of independent assessment that's done from the family law side of things into what evidence was called or how that ruling was made? Or do they just accept that? Because, again, it's not a finding of innocence, it's a finding of not guilty, which is very different. And in my limited experience in family court, there's a lot of times where, again, the complainant or the other parent who might have been present at the trial, particularly against allegations against the kid, say, he was acquitted, but because of reliability issues, or he was acquitted because, for example, if charges are stayed because of a Jordan delay. Like, that's not a finding on the merits. So then what does that ruling from the criminal court really do in terms of how those allegations are treated in family court?
Yeah, it's an interesting question. I think because you'd probably be going down both avenues simultaneously. There would be the criminal charges that are ongoing and dealing with all that, but there'd also be, if it's sexual abuse allegations, there would be that PN5 and investigation. And if there's enough to have charges laid, there's probably enough for that PN5 to take those next steps and investigate further. So if you get to the end of that report and it says they're not substantiated, we don't think this happened, chances are then that you would start building back some sort of parenting time and relationship for the kid. And it probably might be, weekends and that kind of stuff instead of back straight to shared parenting.
Definitely in the majority of the cases where I have clients who choose not to go through family court is when they do involve any sort of more extreme violence or sexual allegations against the children, which they deny. But because it does sound like, what we said in earlier episodes as well, and particularly in family court, they just really look at risk. So if the allegations are there and it hasn't went through the trial, they're going to kind of go on the assumption that there is a risk. And it sounds like there's a lot of extra hurdles that an accused person would have to go through in family court, particularly in those situations. And so, that might be a reason that they hold off, that they wait on going through that entire thing. Because obviously, if they're facing criminal charges, there's been an interview, the police have been involved, and somebody's decided that there's enough evidence to move forward.
Yeah. So there's other avenues you can take through other therapeutic interventions and that kind of stuff that might be a better step than just ignoring everything and waiting till the criminal charges are done. Like, you might even start with some family therapy or reunification therapy, or you could have a risk assessment done of that parent to see if there is any concerns of ongoing behavior like that, just so you can get that evidence. Because I think even if like you said, if you wait for the criminal charges to be done and it's just,
Takes forever.
It takes forever,
Yeah.
for one.
Takes time,
But it's
yeah.
also, they don't get a satisfactory conclusion. Like, there's just not enough, we don't know.
Yeah.
Well, then those allegations are just going to keep going through the family law process. So you're better off taking some steps and starting to work towards something and building up even some expert reports of people that can get involved and look at the best ways to move forward.
Just to clarify a few
I just wanted
things.
to ask you something about kids testifying.
Mm-hmm.
Is it different in criminal court?
Oh, yes. So in criminal court, particularly if the child is the victim or they've been a witness to somebody else being the victim of an offense, criminal court, there's no opportunity for the evidence to go in by another way. So if the child's a witness, they have to testify in court, and if they're not able to testify, and a Crown prosecutor meets with the child, even young children, and determines that they're not going to be able to get through testifying, they're not going to be able to present the evidence in a way that a judge would be able to rely on, then they wouldn't have a reasonable likelihood of conviction. Because most times, particularly in situations of sexual allegations against children, there's almost always no other witnesses. So it's the accused person who's under no obligation whatsoever to testify, and then there is this young child who is the only other witness. So they're the only person that can tell the court what happened, and so they have to testify.
Without the involvement of any third-party expert or professional or anything like that?
So there's no involvement of a third-party expert or a professional, but what there is, so Matt's mentioned the Luna Center. So the Luna Center it's called the Zebra Center in Edmonton.
Yeah.
Other cities have different versions, but essentially it's a child advocacy center. And so when children are involved in criminal allegations, usually as victims, sometimes as witnesses, what happens is the members of the RCMP or CPS, they will do an initial interview just to ascertain kind of the parameters of what we're looking at, and then they arrange for them to go be interviewed at the Luna Center, again by a police officer in criminal cases, but a police officer who's been trained specifically in how to interview children in what is supposed to be a non-leading, non-intrusive manner to get the best evidence out.
Mm-hmm.
And the reason they do that is there's a number of reasons. One, children, they get scared when they go to the police station. They don't really know what's going on. It's not set up to be child-friendly. It's not this room, that's for sure. It's like oftentimes like a cement room with a table and someone sits across from you.
It's like those interrogation rooms.
Yeah,
right?
exactly.
Yeah.
And so children aren't going to want to testify there. So the Luna Center is set up, honestly, more like this room in a more casual environment with chairs and toys and things like that. So these kids feel more comfortable. And more importantly, there's cameras from all angles and an audio recording, because one of the things that the court does do, because children have to testify, is they allow for the children's statement to be admitted under 715.1 of the Criminal Code when certain circumstances are met. The video is taken early in time, it's video and audio recorded, and it outlines all of the offense. But even then, what happens is the child testifies, normally from outside the room, and the Crown prosecutor introduces themselves, confirms that they know that they have to tell the truth, things like that, and then says, hey, do you remember talking to a police officer about this in a room? And just tries to get the child to recall giving the statement. And then they play the video for them and ask them to adopt it. So they have to, ask them questions about whether they remember giving the statement, whether they were trying to be truthful, whether there's anything that they want to change, omit, or whatever at this point. And then that evidence goes in as part of their direct examination.
And they're open to the scrutiny of cross-examination from the defense counsel.
There's no evidence that's accepted in a criminal trial without cross-examination unless it's in an agreed statement of facts. So one of the things I do, I think generally speaking, judges do not like children in court for all the reasons Matt have said. It's traumatic for adults. It's 100 times worse for children. And children almost always are involved in criminal matters involving people they know or people they trust. And so it's even more traumatizing for them because they're in a position of trust or a parental position or a sibling position or something like that, right? And so they have to go through cross-examination. But one of the things I do to avoid that is, particularly if they're witnesses to an offense, I will try to see if there can be an agreed statement of facts we can do so the child doesn't have to testify. Because
how do you toe that line? I mean, as a defense lawyer, cross-examining a child who's made these allegations, I mean, that's a very difficult position to be in.
Yeah.
It isn't. I mean, one of the things about cross-examining children is they're highly suggestible, and they don't want to be
good.
there.
That might be good for your client.
That's what I'm saying. So from a defense perspective, I mean, is there definitely a line to toe? Yes, but it's also a situation where, as defense counsel, you're not readily going to admit everything that these children say for a whole host of reasons. One, if your client has told you it didn't happen. Two, if you think there's any evidence that they've been coached or pressured into giving that statement, particularly against another parent, things like that. But definitely your cross-examination strategy dealing with children, very different in terms of tone, in terms of demeanor, in terms of how you frame your questions, for sure. I mean, the thing about children's evidence in criminal matters is The burden of proof can't change, so the evidence has to be treated with just as much scrutiny as adult testimony is, but they're given a little bit of leeway. So it's clear that children remember facts differently. They remember what they consider important is not the same as what an adult would consider as important. They might not remember dates or time or certain descriptions. So weaknesses in those areas are not treated as significantly as they would be if you couldn't remember what day it was, or you couldn't remember how many times something happened, because kids don't form memories that same way, particularly young children.
That's a pretty stark difference in procedure between the two.
Well, it's
Actually, yeah.
Yeah.
I wonder why that is.
Yeah.
Well, I think the reason why is because in criminal court, if somebody, the burden of proof is very high, obviously, and just because children are the victims or the witnesses, at the end of the day, it's the benefit of the doubt has to go to the accused. That's the whole premise of our criminal justice system. And so there is no happy medium or even medium like you might be trying to get to in family law. Like in criminal law, it's just whether or not this person should be found guilty. And they cannot be convicted on anything but fully tested evidence. And so, I mean, definitely there are a number of people who think that there has got to be a better way to deal with allegations involving children than criminal court. Because in a lot of situations, children, for no fault of their own, they're not reliable witnesses. Because their memories aren't great, and they've had a number of people talk to them about what happened, and your brain will rewire what you remember, rewire what you think about.
It's moldable.
Yeah, and oftentimes, you know, as defense counsel, we call witnesses, expert witnesses, to testify about that remolding, about, you know, whether or not you can be satisfied that this is their initial genuine memory, or whether this is something that's changed over time. And so there's definitely, like I said, there's definitely a lot of people, for the reasons similar to why family court doesn't think that children should be involved, that there should be a better system, a better diversion option or something involving children. But it's a catch-22 because you don't want to put the kid through that. But if these things did in fact happen, then that person should have a criminal record and the public should be aware of it and there should be consequences. And so there's no happy medium. There's no answer that solves both those problems. But definitely I don't know of a single example in criminal court where you as the accused are not entitled to challenge the evidence through cross-examination. And if it's a kid, then that kid's getting cross-examined.
But obviously nothing like that in family.
The cross-examination goes towards those experts that go up there,
Right.
Like you would, if there was a practice note 7 report, you would go up and challenge how that report is handled and whether what they've actually found is reasonable. Or if there's any issue of any coaching, then you're going to really draw that out in the cross-examination, and that, okay, well, you know, that's what they may say, but here's, you mentioned all this stuff about coaching and that kind of stuff. So how can we actually listen to these voices? And that's how it's challenged instead.
You've been mentioning practice notes. Are those attached to the legislation? Those are from the court.
It's from the court. Yeah, they're kind of attached to the rules of court. Yes, you find them on the Alberta Court's website. They're not part of the rules, but they're like the civil has its own practice note, and family has practice notes, and it sets out certain guidelines. Like practice note 2 under the family practice notes breaks down all the rules on how you can do your affidavits and what you need for a special or morning chambers or all that kind of stuff. And then there's a few other ones out there.
So for your colleagues in your Vancouver office, they'd have a completely different set of these.
Yeah, they have different things out there. Yeah.
Have you practiced with your Vancouver office at all?
Yeah, there's a lot of interjurisdictional matters that we have. You know,
Right.
there's property in Alberta or
Mobility.
BC, and mobility stuff. Or some of the ones I've had is similar to yours, where one of the parents have ran off to BC, and then you got to figure out which jurisdiction would be better to bring that urgent application to, because that's always a thing to consider. Yeah.
And do you think, particularly with dealing with the children's evidence, does British Columbia deal with it do all the provinces deal with it in a similar manner?
I think it's very similar. They call them all, I think it's a 211 report or something out there. But
Same principles.
Same principles, yeah. Because the Divorce Act is also federal, right? So it goes across all the provinces, and then family law acts in each province is going to be a little bit different, and then, you know, the rules of court are going to be a little bit different in each province. But basically, best interest of the kids, that's what you're focused on.
Right.
Yeah.
And just looking at the mobility order, just going back to Tahir's story about the MMA fighter and the exotic dancer. If you do have a mobility issue, have you ever had a situation where them not returning the child, with respect to a mobility order, or not returning the child with respect to a parenting order, or that has led to the involvement of the police, there's a number of charges.
There's a police clause. I think Matt will be able to expand on that a little better.
Yeah.
So there's a police enforcement clause goes into a lot of high conflict parenting orders, not just on mobility, but just parenting schedules in general. Again, the courts do not like them. They're kind of a last ditch effort. They're not a status quo. And if there's no high conflict issues, I've had them denied when requesting them before as well too. And that's simply because you don't need to add that toxic stress of someone calling the cops on the other parent just when they don't get their way.
Mm-hmm.
Yeah.
People are expected to follow orders or come to agreements. Every parenting order and everything you're doing with kids is, unless mutually agreed, the courts want parties to be able to work together and not have to keep coming back all the time. So they will have that in there. But if you can't work together, then you fall back to what that order says. And if someone's not following that, then because it's high conflict, there will be a police enforcement clause. And depending on the wording that the justice wants to put in there, it could be as simple as the police can help and go pick up the kids, or it could be they'll go get the kids, and if whoever didn't follow this order can also be detained.
Yeah. My understanding is there's a number of different wordings, and depending on what section it's under, it can either be a civil breach, which would be handled in King's Bench, or it could be even a criminal charge
Right.
of breach of court order.
Have you dealt with cases like that where one parent has breached an order where you have a police enforcement clause that they've been brought to charges?
So I've dealt with people that have been charged for breaching the parenting order, not necessarily just with police enforcement clauses, because oftentimes if there's a charging clause in there, it applies to all of the conditions. So for example, if one of the parents spoke to the children about something that they're not supposed to, or sent text messages when they weren't supposed to, then it would be a no contact breach. And it is very important about what section is there, because there have been times when I've went to court and I was like, look, this order doesn't actually allow you to lay a breach of order charge. Like, you have to deal with it through King's Bench civil, like a civil breach. And so then the Crown's, it's want of jurisdiction, so they're not able to prosecute. The thing with the police enforcement clause is a lot of times it leads to breach orders, for sure. But it also, in high conflict situations, the police generally show up at someone's door who don't think they should have to send their kid back, and will try to have a reason, and a lot of times it leads to resist arrest charges,
Right.
assault PO charges, unlawful confinement charges if there's some reason, like if they're not allowing the child to leave, things like that. And so it can very quickly escalate, even into just depriving the other party unlawfully of access to the child and things like that. I had a matter once, or I'm aware of a matter once, where somebody picked their kid up from school and flew them out of the country. And it wasn't contrary to a court order, but it was contrary to a written agreement that the parties had. And like, when I say it was a full-scale response, like there was like police officers on a plane flying to Europe, detaining the father, gets put in some sort of detainment situation through the convention, and then the child was escorted back, and that led to a number of criminal charges. And it was crazy because in that situation, they were amicable. Like, up until that point, everything had been amicable, and then something like that just derails it completely.
Yeah, I've heard stories like this, but I guess you would need to have that convention in place, right? Because I've heard of parents
taking convention.
Taking their children to countries that don't have the convention, and there's no option then, right?
Yeah, because there's
no recourse.
One of the reasons why this was such a full scale is because there was 2 connecting flights, but they were going somewhere that was not a signatory, and so they were like, we need to interfere before they get in that jurisdiction, because then there's nothing.
Yeah, once they get into that jurisdiction, then the party trying to bring them back has to start a whole new thing out there, and then figure out the law out there, hire a lawyer out there, and then have an order bringing them back. And a lot of those courts in countries that aren't signatures, they're pretty weirdly strict on what their jurisdiction is. They don't want to give it up to anybody. So if the kid ends up there,
They're not giving
they're
it
not
up.
giving it
Yeah.
up in those applications. So yeah,
It's also interesting how few people understand how quickly this family dispute can become criminal charges. Because in a number of situations I've seen where the police are called, enforcement there, you know, I'm in court and neither party wants it to be criminal. And at that point, it's too late, right? Like in Canada, it's up to the police or the Crown Prosecutor to charge, and it's up to the Crown Prosecutor whether they're going to proceed. And so then you end up with two people being like, look, we just thought we could call the police. And now we're in criminal court, we're in family court, we're not allowed to talk about our finances, and my kid can't see their other parent, and they're really upset. And so it's crazy how quickly it escalates once the police enforcement's taken advantage of.
there's that reason that I think we talked about it in a previous episode about that cool off period a little bit. The EPO, the emergency protection orders, when you get that, it has to be back for review in 9 days. That's kind of your cool off period, and then you can decide whether that needs to continue or you can vacate it there, right? And so it gives you that time to settle down, and everybody can come with cooler heads. Or
In
that's
your
the hope.
experience, is that normally what happens? Is there a higher percentage of people that use that time, take a step back, and realize they can probably reach an agreement?
Most of the ones that I've dealt with turn into mutual no contact orders.
Yeah.
Leave the kids off. The two parties will not communicate. Yeah.
And just
'Cause
figure it out
that's
from
what
there.
that's what they want at the end of the day, is just, I want to be left alone by him, or I want to be left alone by her, but we still have to parent. So how are we going to do that? So kids are left off, and we just won't communicate.
And like you said, the courts, almost all of the orders are unless mutually agreed. Like, they really want parents to co-parent. Like, you
Yes.
co-parent together,
Yeah.
co-parent separately. At the end of the day, they just want you to work together for the best interest of the children.
Yeah, you probably would have heard of something called like parallel parenting. That's a term people throw around. Courts don't like that either. That's just having the kids living two lives in two different households. That's not what they want. They want the parties to work together and
Yeah.
co-parent. And whether that means not communicating a whole bunch and just sending messages on some sort of app to update the other one, that's fine. But having the kid living two different lives in two different households is also not
Just
great
not
for
what
them.
they're looking for.
Yeah, so they want them to be able to communicate. And quite frankly, both those parents are going to want to go to a graduation. They want to go to a wedding. Last thing you want to worry about is not getting to go to your kid's wedding because you and your ex can't communicate or be in the same room together. So at the end of the day, think about them and not your bitterness or what the principle of the matter might be, because that doesn't matter.
Yeah. There's, my dad had marriages before, so there's two of my sisters before, and one of them, neither myself or my dad really has any relationship with, and when I talked to my dad about that, it was just a really contentious, toxic relationship about how to handle the children, and there was like mobility issues, and it's very interesting to hear that story and then hear how the courts now are like, no, that's just not working. It hasn't worked. We're not going to let that happen anymore. Yeah, it definitely has lasting consequences for sure.
Yeah. Even between Edmonton and Calgary, we have a very amicable bar. Everybody will work together, and it's also like really the courthouse in Calgary will push you towards to mediation a lot more. That's something that Edmonton just kind of started doing, in my experience, like a few years ago. Now it's a rule that you have to try mediation before you can do anything in court. But before, you would go into a courthouse in Calgary and like, well, have you mediated? No, well, I'm going to give you an order to go try mediation, then come back. In Edmonton, my experience has been, it's like, well, I'm seeking like some sort of mediation resolution. It's like, oh, no, we're not going to do that. Go to a trial.
Really? So Calgary is kind of ahead of the curve.
Yeah.
There.
Well, don't feel pressure to answer this question a certain way, but is the family law bar amicable?
For the most part, yeah. For the most part, it's pretty good in Calgary. There's a lot of good lawyers, and most of us see that our job is not to, get the other party and try to really be, everybody says that they want a pit bull of a lawyer, but what you want is someone who's willing, able
Get
to
you a solution, right?
Yeah, to a solution, and can pick up the phone and talk to the opposing counsel and be like, here's the issues, here's what we need to work on, because you might get it done on that phone call. If you just come out guns blazing, then that's when you're off to a long litigation.
And it's like you said earlier in a different comment, like you need to decide if you want to have your money in your bank account to spend on your kid, or if you want to have your money in my bank account so I can spend it on mine.
That's right.
Like, this costs a lot of money.
Yeah.
It's not
Yeah.
just court time.
And it's not even just the money and my legal fees. It's your opportunity cost because of the time you're spending dealing with all this
Yeah.
that you could be just working or living your life, and the emotional toll. Right there is a big number there that what you're going to be going through. Like, and a lot of times, I finish a mediation and my clients call me the next day. They didn't really want to settle. They didn't want to take that. But they call me the next day and tell me that that was the first night's sleep they've had in 2 years, and like they didn't dream about spreadsheets or anything like that, and they just are so happy that they got it done.
There is a stark
Yeah.
difference though in practices, because with civil litigation, whether it's personal injury or whether it's a construction dispute or anything like that, and even to an extent with criminal, it's not personal, right? When I'm dealing with another insurance adjuster resolving a claim, it's not personal. It is for my client, but it's not for them. And similar to criminal, I think that you're dealing with a Crown prosecutor. They're not personally involved in the
they're
situation.
not supposed to be. Yeah,
Right.
that's correct.
Which is different. That's what makes family law unique, is that on both sides you're dealing with a situation that is highly personal. You're dealing with your personal assets. You're dealing with your children, right? And that brings out the worst and even the best people, right? So have you seen that, even with yourself sometimes, kind of involving that emotion on yourself, or seeing that from another lawyer, that they're kind of involving themselves in the case themselves?
It happens far too often, where I see the lawyer getting too personally invested in their client's story. It almost becomes their life that they're doing this stuff for, and it's our job as family law lawyers is to be an objective advocate, right? Mm-hmm. So we still fight for our client's position, but in the back room when we're talking, I'm going to be pretty blunt about your chances and whether this is going to be worth it. And that's the conversations you're supposed to be having. And too often I have seen lawyers just don't see it. It's my client is telling me this, and what they're saying is gospel, and it's got to be this way no matter what. And it can ruin what could have been an amicable relationship and really blow it up. And so that's what we got to focus on more.
It is hard though. Like, there's definitely been some files where I have been more personally involved than I have in other ones, just because of the facts or what's happening to your client or things like that. But I mean, I've chatted with you about family law cases the whole time that you've been practicing family law, and you always just seem to be just unbiased, neutral,
Even
something
keel.
that I strive to be on a day-to-day basis. I try to pull it off in court, but at the office, not so much. But I think one of the things that I've learned throughout my whole career is just stepping back and remembering that it's not your children, and it's not your criminal record, and it's not your job. It's your job is to defend them or represent them or whatever, but you really have to keep that barrier up.
My clients aren't served by me telling them what they want to hear, or just parroting what they want to say to the court or to the other side. My clients are better served by hearing objective legal advice on what their risks are and what it's going to cost them to get what they want, and whether that is worth it, right?
Even if that's not necessarily what they think they want to hear. Yeah, they want somebody who's going to be on their side, and sometimes it's like client management explaining to them that I am on your side, but what you are saying is not where we're going. When
I'm in court and I'm arguing on your behalf, I'm on your side. I'm going to do everything I can. But when we're in that back room or in my office talking about your risks and trying to resolve things, I'm going to be very blunt about what's going to happen and what could happen to you if we don't get a resolution on that side, because that's what you need to hear. Not like, you've got a great case and we're gonna go smash it. Because anytime you go to court, you roll that dice, right?
It's inherently risky. Litigation is,
One thing my mentor said to me from the time I was articling, he's like, set expectations low and land high. Like, that's how you want, never overpromise. Right? Under promise, overachieve.
Yeah, you need to know what to expect, because the justices, as brilliant as they all are still people too. So, specifically in something like morning chambers, they've got 20, 30, 40 matters to get through in a morning, and they're supposed to give 20 minutes to each one. So they've read all these affidavits, and they've got to make a quick decision. They might not have had breakfast that morning. They might be grumpy. They might not have. Their spouse at home might have done something to piss them off, and they come in, and then all of a sudden now they have a similar story in front of them. Like, well, here we go, right? So like they're people too. They're gonna make it. They're gonna make mistakes, and
sometimes they just don't see it your way. Like
Yeah.
I've ran some files in front of justices. One of the last files I did at the Crown's office, where I was like, "This is so obvious,"
yeah,
and the justice constantly looked at me like she thought I had completely lost my mind.
yeah,
And it was a really serious charge for sure. And to this day, we don't see a single part of that case the same way. And I went in being like, it is a very obvious case. And so sometimes they're just not, and your client needs to be prepared for that.
yeah.
They
Very
need
similar.
to be prepared.
Very similar thing. I went into morning chambers on trying to do something into arbitration, and the justice was like, "Well, I don't agree that I've lost jurisdiction. I'm a justice," and we went into it. Fortunately, I managed to turn it into an adjournment, and then we went to the next appearance, and that justice is like, "Yeah, the Arbitration Act is clear. What are you guys doing here?" And I'm like, "Thank God I adjourned it." Right?
You're like, well, that is a good
Yeah,
question.
because but two justices, same matter.
Yeah.
Saw two different ways. Yeah. So
You
you
gotta be prepared, and your client has to be prepared, because
Yes.
nothing makes your client have less confidence in you if you're like, this is gonna be a-okay, don't worry about it, and then you walk in and you get ripped apart,
Oh,
because
yeah.
then they're like, oh, you have no idea what you're talking about.
Yeah.
So I tell them all the time, this could be the best case in the world. You need to be prepared that they might not think it's the best case in the world, and then we'll figure it out later.
Yeah, which is another plug for mediation and mediation arbitration.
Yeah.
Keep it out of that court if you can. Work on that resolution yourselves by hiring that mediator and trying to come to something that'll work for you, because that's going to be a more long-lasting resolution than anything you'll get even going to a trial. Because at the end of a trial, and someone's not happy with that decision, well, then there's appeals. They're just not going to follow it. They're going to do whatever. You
Becomes costlier, more
and
time
try to
consuming.
enforce everything. If you come to that resolution together, then they're like, okay, well, I agreed to that.
Yeah,
So,
and I particularly from resolutions, one of the things I always ask my client is like, what is like the best case? Like, what are you looking for to get out of this? Because if there's a way that we can resolve it that way, it is 100% better to have control over what the outcome is.
Yeah.
Because once you're in court, once you're in family court, once you're in criminal court, even once you have to run trials in civil matters, once it's up to a judge, you don't have any control. You can call the best evidence that you think, you can try to argue, but the control has officially left you. It's gone.
Yeah. I always tell people, I say, if you go to litigation, you have to be prepared to lose.
Lose everything.
And if you're not, then trial isn't for you.
Yeah.
Right. So
100%.
thank you, Matt, for doing this series with us.
Appreciate you guys having me on. This has been a lot of fun.
These are really difficult issues. I think more so some of the most difficult issues that face the legal practice are family law issues. So I think you sharing your insight has been invaluable to our viewers, and thank you very much.
Absolutely.
Thanks so much, Matt.
Yeah, probably a lot more we could talk about, but we'll do that another
Always.
time. Yeah.
Always.